Ashley Benefield, a former model and ballerina, finding herself at the center of a high-profile trial after being accused of shooting and killing her husband, Douglas Benefield. Claiming self-defense, Ashley's case sheds light on the complexities of domestic violence and the legal challenges that arise when trying to prove justifiable force. All this weekend on the Hidden Killers podcast, we're examining the case of Ashley Benefield, examining the events leading up to that fateful day in their Lakewood Ranch, Florida home, and the allegations of abuse Ashley made against Douglas. We're taking you to the courtroom for raw audio from the Stand Your Ground hearing of Ashley Benefield all weekend here on the Hidden Killers podcast.
Okay, can you bring Miss Murphy, Attorney Murphy, back in? Thank you. All right, welcome back, ma'am.
Thank you.
Do you ready to try and discuss the case with you or anything about your testimony?
No.
All right.
So we were talking about the end of the hearing on September 17th, 2020, where Judge Moreland made a oral order.
Correct. She made an oral ruling at the conclusion of the hearing.
And was the defendant present to hear this ruling?
Yes.
She was in court then?
Yes.
All right. I'm going to show you State's Exhibit number 1. Do you recognize that?
I do. Those are my initials.
Okay. What is it?
That is the CD of the oral pronouncement at the end of the injunction and emergency time-sharing hearing.
And you said these are your initials. So
correct.
When you listened to it, did it accurately reflect your memory of what was said in that hearing?
Yes.
State would enter in evidence State Exhibit 1.
Same objections?
Yes, sir.
Yes, sir. Overruled for the same reasons. I'm not accepting it for the truth, just the effect on the listener.
Okay. And then the state will publish it's about 10 minutes long.
I think Mr. Sessions start with that one thing, even though I find it very reticent to ever say, well, someone else investigated this, so there's no problem. But I do appreciate the fact that Mr. Sessions argues that people investigated and found that his client wasn't the perpetrator of any domestic violence, etc. Because I just read a report by a doctor that just indicated that he had done a full battery of psychological evaluations on Mr. Benefield in this particular case. He had absolutely no concern of self-harm, domestic violence, or any other type of spurious activity on the behalf of Mr. Benefield. Let me just go ahead and say as follows, that this court will find that as far as credibility is concerned, I would find, and I'm going to say this in the gentlest form I possibly can, that there is absolutely not a single scintilla of credibility that I'm attaching to anything that was testified to, at least in this hearing of Ms. Benefield. Court finds that it starts from basically the absurd of the conversations of what she would have had with a child, searching the room, finding a shadow box, being so upset, but also at the same time the testimony where she said, well, they were absolutely liked me a lot. They confided in me every conversation. I knew all these horrible things were going to happen because the girls felt good talking to me. We then move forward to the actual presentation that she's had in this courtroom since she entered into this courtroom, the turning on of tears when she thinks it's appropriate, and then we move on to the entire insinuation that there is some type of poisoning going on in this particular case. There is not a single scintilla of credible evidence that Ms. Benefield has ever been poisoned or suffered from any illness of any poison. Court finds that Dr. Hilliard's testimony was suspect. I don't think that the court finds that he reviewed one record appropriately. And in comparison to Dr. Sawyer, I think his testimony, in a word, was bunk. I do find that Dr. Sawyer's testimony was quite informative, and that his information concerning the answered questions that I had, how there were testing for certain metals on and then testing for certain metals that weren't there. And most important to this court was the explanation of the misinterpretation or the use of an improper range which I think even in cross-examination there was a misunderstanding that there is a range that these metals are in the human body, not just a single number. So that brings us to the following timeline. I have that in 10/20/2016, there's the respondent goes up there. They're at the respondent's home. Petitioner is up there. He's had back surgery. She moves back into the respondent's home permanently on December 2016. That in about January 2017 through, I'm going to say 5/8/2017, there appears to be a marriage in which there are arguments, but there is still a very committed relationship to the point where they're talking about having a reversal of vasectomy to have a child. That on 5/8/2017, the clear evidence is that there is the vasectomy alteration or reversal, and that from that point they begin to pursue having a child. The court will find there is one incident of alleged domestic violence, and I got to tell you, it is de minimis, even though it's huge. Whenever how it was executed, the shot into the ceiling, the court is going to find that at no time was the shot by Mr. Benefield at or in the direction of Miss Benefield. The court has seen Mr. Benefield testify, and the court finds that Mr. Benefield is taking on responsibility for that single misstep. But that is a remote type of domestic violence that has occurred. Subsequent to that, it is clear that Ms. Benefield continued to pursue a relationship and to have child with this gentleman, that she had a lavish wedding, invited numerous people there, had many people that she could have confided in, saying, I'm in a hellish situation, things are out of control. Just last week he shot a bullet in the ceiling. That's absolutely not what happens. Instead, she goes through with this lavish wedding. She goes on developing a ballet with her husband at that time, posing in magazines, portraying to everybody in the world that this is a very happy marriage, that we're going to start this national ballet at a significant cost, both emotionally, physically, and financially to the parties. That they finally find out that in July of 2017 they have conceived a child, and that, or they think that that's the date they've conceded in retroactive review, which tells this court that during that period after the shot, that they were still engaging in a intimate relationship. The court does not find credible any type of animal cruelty in this particular case, nor does the court find that the other incidences alleged of punching the wall were ever directed completely at her, nor were they meant for intimidation. Court's also going to find that at 3/2017, they do find about the pregnancy. It's confirmed. And at that time, because of illnesses due to the pregnancy, it is determined as a family, as well as because of the ballet, that they're going to move Mrs. Benefield to Florida from South Carolina. During all this period of time, what we have is a household that is continuing on. Ms. Benefield being in the home, not making anyone alert. The medical records are devoid of any conversations between her and people that would have been providing protection, those being doctors, etc., indicating in the least that she has any type of poisoning that is appearing in her system, that she has been the victim of domestic violence, and or that this child, Eva, has been the victim of domestic violence. Then we go on, and suddenly we have, she moves to Florida, but even in Florida, we have Irma come through, I think September 11th, that weekend. Mr. Benefield comes all the way down. He makes sure she has a generator she needs for the storm. He then leaves, and she feels comfortable enough and well enough to go all the way back up to the home that she shared with Mr. Benefield to collect property and transport those items down to Florida for her own use, and without any fear that this gentleman is going to harm her when she's up there. The court will, one of the other things allude to as far as credibility problems were the issues concerning the split records that she's asking the Lakewood Ranch to have to, I guess, somehow cover any type of problems or contradiction there might be with the poisoning allegations, as well as the emails that were introduced today between the cousin of Mr. Benefield and Miss Benefield I guess, trying to curry some kind of upper hand in in either of these two cases against Mr. Benefield. Court's also going to find that the wife has at this time demonstrated a complete disregard for allowing Mr. Benefield to have any active role in the birth of his child and or the life of his child that he has now not had any contact with. The court's going to find there's been no violation of any injunction. The court did look at and has listened to the testimonies that were provided concerning the injunction that was entered. Quite frankly, it sounds like the court was when you listen to the transcript, was actually telling both of them they needed to stay away from each other, and that certainly there was no violation of it whenever there was the oral pronouncement, only to be followed by a written pronouncement. Court is also finds there are some issues with the credibility of Miss Benefield when she's actively sitting here telling this court she doesn't like to have publicity, but at the same token she's participating in articles concerning the alleged poison, etc. As far as the last comment on the poisoning, there is not one piece of evidence, like I said, that has been established that even if she was being poisoned, that there has been a suggestion of a nexus of the who, how, and where the poison. That would be rank speculation for this court to jump into the idea that because it happened, it had to be him, especially when I have in all senses, not a credible witness is the only person that's asking me to speculate. So with that in mind, the court is going to find that at this time, there is absolutely no evidence. And I'm saying no evidence. I'm not saying by the preponderance of the evidence standard, that hasn't even been close to that there's been a indication that there's an immediate likelihood of domestic violence. There's only the one remote incident. And as of today, there's no reasonably prudent or logical person would think that you're the threat, that you're being threatened by immediate domestic violence. So for those reasons, the court is going to deny the request for an injunction in this particular case.
So after the judge's ruling on the injunction, which would be the defendant's motion, did she make a ruling on your motions?
Yes.
And that was time sharing with the child?
It was time sharing and parental responsibility.
Okay. And what was the order, or what did the judge say Doug could do?
There was a temporary time sharing schedule that was increasing in frequency and amount. So it started with the first day that he was going to be able to meet his daughter, just a handful of days later. After a period of time of seeing her according to the schedule, then it jumped up to weekend time sharing, overnight sharing, then there was another jump, and so he was able to take his daughter back to South Carolina for time sharing. There was also, I believe, some extended visits, maybe holiday related, but then the other main component of that order was with regard to shared parental responsibility, which again is the decision making. And Judge Moreland ordered that Ashley and Doug were to exercise shared parental responsibility so that they would have to confer and make a good faith attempt to agree on major decisions. But the court specifically ordered that Doug Benefield would have ultimate decision-making authority regarding health-related or medical issues. And the order made very clear findings about her extreme concern with regard to Ms. Benefield's medical decisions up to that point. Which is why she ordered the ultimate decision-making authority.
And the concern was for the medical decisions for the child?
Correct.
So why is there an escalating frequency of visitation with the child?
Well, Doug had never even been allowed to meet his daughter. So she was, I believe, 6 months old by the time he met her. And so it's just appropriate that you don't just dump a baby with, who was that at that point, a stranger.
Okay.
So it was just to grow in a reunification, or a unification, I guess. There's nothing to reunify.
To get the child used to who she was going to.
Exactly.
Okay. So the first time sharing where there was an exchange of, and the daughter's name?
Her name is Emerson Grace Caney.
Okay. And can you spell the last name?
I believe it's Caney. I have to double check my file to be completely certain.
Okay. And where were these exchanges of custody to take place?
Well, according to the court order, they were to take place at Manatee County Sheriff's Office, and that's where the first exchange took place.
Were you present at the first
Yes,
exchange?
I was.
And did you arrive with Doug, or were you separate?
We arrived separately. By the time I arrived, he was already there. We were both there earlier than the scheduled exchange time.
And was this the first time Doug was meeting his child?
Yes.
What happened during this exchange? Did the defendant ultimately show up with the child?
Yes, she did.
And just explain how that meeting went.
Okay. I had been sitting with Mr. Benefield in his truck, and when he saw Miss Benefield enter the parking lot, he moved the truck closer to the entrance to the building, and she was out in front of the building with the child. Doug and I then approached Miss Benefield, and I hung back a bit, and Miss Benefield saw me, looked at me, and then immediately said, "Are you dating her?" She was very indignant, very upset, and then I responded to that question. Of course, I said no. And then they proceeded to have a conversation where Doug was trying to engage with Emerson, talking to her, ultimately was able to hold her. And Miss Benefield was in very close proximity to Mr. Benefield, probably less than from me to the judge's bench, especially when she transferred the baby over to his arms. They kept talking for 5 or 10 minutes or so, and I kept waiting also there. Then Mr. Benefield turned to me and said, "Okay, we're going to go. Ashley's going to come." And so I pulled Doug aside. We had a communication about it. I warned him that it was not a good idea given all the allegations that she had raised up to that point. And he said that he was aware of the concerns. He agreed with me, but he wanted Emerson to be comfortable, and he thought having Ashley there, as she was insisting, would help Emerson be a little bit more comfortable. So then I watched them Miss Benefield strap Emerson into the car seat in the back of Doug's truck. She got in the back seat, and they left. I, of course, just left in my own vehicle.
And approximately when was this?
This was September 21st.
September 21st of
2018.
2018.
Just a handful of days after the hearing.
There is more to come in the Ashley Benefield Stand Your Ground hearing. We're bringing it to you all weekend long here on the Hidden Killers podcast. Press subscribe so you don't miss a minute of courtroom coverage. I'm Tony Bruschi. Stay with us.